Good morning, everyone. It is Wednesday, December 17th. This is the Colorado Energy and Carbon Management Commission. Um, our chair, Robbins, was not able to attend the hearing today, so I am going to be chairing our meeting today. Before we begin with a roll call for commissioners, I do just want to note that due to the inclement weather today, as I think many, if not all, are aware, Xcel Energy may be shutting off power across the Front Range as a safety precaution in the event that those outages affect ECMC's ability to conduct this hearing. We may adjourn, and any pending matters that we have not been able to get to, will be continued to our next meeting, which is January 7th, 2026. So with that, let's begin with a roll call of commissioners.
Thank you, Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Robbins. Madam Chair, you have four commissioners present.
Thank you. Next on the agenda is commissioner comments. Any commissioners with comments? Okay, not seeing any today. Next is our consent agenda. Any questions or comments on consent?
I move approval of the consent agenda. Second.
Thanks. We have a motion and a second. All of those in favor signify by saying aye.
Aye.
Aye. Any opposed? Motion carries 4-0. Okay, so next on our agenda is an executive session. We are looking to receive information, legal advice, and analysis from our attorneys on the next matter, which is a motion to stay cross-contested OGDP docket numbers 250-30040 and 241-200-311. AAG Boudreau, anything further to note for executive session?
Thank you, Madam Chair. I have something I need to get through before we can move on to a motion. Do you mind if I go ahead with that?
Please.
Thank you. Pursuant to the Open Meetings Law, the Commission is entitled to enter into executive session at this regular meeting to receive legal advice pursuant to Colorado Revised Statute Section 24-6, 402-3A2. During the executive session, the Commission will receive legal advice as described on today's agenda regarding the motion to stay cross-contested OGDP docket numbers 250-300-040 Verdad Resources LLC, Pergamos Fed 0315 OGDP, and OGDP docket number 241-200-311 Red Hawk Petroleum LLC, Waves Fed 1510 OGDP. Madam Chair, you can entertain a motion to enter executive session for the matters and purposes I just named.
Anyone care to make that motion?
So moved.
Second.
Thank you. I have a motion and a second. All those in favor? Aye.
Aye.
Any opposed? Motion carries 4-0. We will be shifting into executive session. For those of you here joining us virtually, hold on here in this Zoom. Commissioners and our council will return after we've completed our executive session. It's hard to know exactly how long that will take. I anticipate this one won't be significant in length, maybe 20 minutes or so, but in any event, please, thanks for your patience. We'll be back. Executive session, AAG Boudreau.
Thank you, Madam Chair. We are returning from executive session. During executive session, the Commission received legal advice regarding the motion to stay cross-contested OGDP docket number 250-300-040 Verdad Resources LLC, Pergamos Fed 0315 OGDP, and OGDP docket number 241-200-311 Red Hawk Petroleum LLC, Waves Fed 1510 OGDP. No decisions were made and no votes were taken. Madam Chair, you can entertain a motion to exit executive session.
Actually, I'll go ahead and make that motion.
Second.
All those in favor?
Aye.
Any opposed? Motion carries 4-0. Thanks all. Okay, so that brings us to commission deliberation on the contested motion to stay proceedings in the cross-contested OGTP dockets 250300040 and 241200311. Commissioners, before we enter deliberations, do any commissioners have questions that they would like to raise to the parties? Commissioner Messner.
Uh, Thanks, Madam Chair. At this point, I don't think I have a questions for the parties. I would, if it's appropriate, be interested in deliberating a bit and then potentially asking party a question based on discussions we may have during deliberations.
Okay, sure. All right. Does any commissioner wish to begin deliberations? Commissioner Messner.
Thanks, Madam Chair. So a couple of thoughts to just kind of start the conversation here. And having read all of the information that's provided in the docket, pre-hearing statements and the response statements and associated evidence, I think a few things. I think one, the parties have agreed to consolidate. And so really, I think what we're looking at here is a decision on whether to grant the consolidated stay request. Not that both parties are agreeing to the stay request, but to grant the stay request provided by Verdad, or to go to a contested hearing. I think one thing that's important is that, as was indicated, in some of the pre-hearing information is that in a previous similar but not the same issue before us between Kerr McGee and Verdad, there was an order that was developed, and the decision at the time by this commission on that particular unique situation was that there was nothing contained in the act or the rules that would allow the commission to resolve this dispute between these two applicants. I think it's important to note that this was not a standing order. This was only a decision made on the merits of the particular application that was before us at the time. Logic may indicate that the commission may make a similar decision in a similar situation, but each application is reviewed and determined on the merits of the particular application or applications, and there's no precedent set by prior decisions by this commission. Having said that, I think I want to communicate to both parties that hypothetically, I as a commissioner may find it very difficult to come to a conclusion in a contested hearing that is different than a potential denial of both applications. As was indicated in the previous order, there is nothing contained in the act or the rules that would allow this commission to resolve this dispute between these two applicants. There's nothing in the rules of the act that provides this commission clarity on determining that one application is more protective than another application, sans one application not being determined to be protective at all. There is clarity on the rules, however, that applications can only be approved if they are found to be protective of public health, safety, welfare, the environment, and wildlife resources. Having two applications targeting the same minerals causing the drilling of unnecessary wells affects mineral owners' rights and causes subsurface conflicts that would not be protective, and therefore hypothetically could cause denial of both applications. Now, having said that, if the parties do want to move on to a contested hearing, I don't have a problem with that. I think it's important to note that, all options are on the table, including options that are different than what was determined in the previous unique applications that were before us. But it would seem more productive for the parties to take some time to work this out before coming to hearing. And so I'm also have no problem with looking at potentially granting a stay today to allow for that to occur. So those are my initial thoughts, Madam Chair, and certainly interested in other commissioners' thoughts on the topic.
Thanks, Commissioner Messner. Others? Commissioner Cross?
Thank you, Madam Chair. I'm going to be a little more blunt in my comments. I'm fairly frustrated that we're having to hear these kind of arguments at all. I know a lot of commission hearings used to be specifically about these kind of competing OGDPs before 19181. And I think with the more intricacies that are involved in OGDPs now, we don't see those competing OGDPs as much. But ultimately, I think what used to happen is there would be business agreements that could be made, whether it was swaps of assets or swaps of working interest, et cetera. And I think that's what should happen here. But I'm also kind of to the point where I think decisions need to be made. And so I'm not in favor of a stay at this point in time. I think the parties can try and work it out before we get something set, but I'd like to see something set so we can just make a decision and get people to kind of stop waffling on these and pushing things off.
Commissioner Ackerman?
Thanks. I don't have a lot to add. I appreciate Commissioner Messner's comments as well as Commissioner Cross's. And, in a very similar situation, as Commissioner Messner pointed out, we stayed this issue, but we stayed it specifically so that people could go work it out. And we directed them to do so. And, to me, the benefit of a stay is really procedural. It's, that the operator's not having to start from ground zero with a new application after hypothetically we've denied both, right? As Commissioner Messner said, is potentially on the table, and in my opinion, certainly a possible outcome of a future hearing, depending on how that goes. That said, I think we're kind of picking between two ways to try to get the operators to go work it out. Do we put a stay on and say, we'll give you some time and then we'll come back in a year and a half as we did before and say, we still didn't work it out. And then through those proceedings, there was an agreement that did work it out. That's what we're aiming for. So to me, it's about the most efficient way to do that and the most efficient use of this commission's time. Certainly, I think the most efficient use of this time isn't as a contractual dispute arbitrator, nor can we do that. So I'm pretty much in alignment with Commissioner Messner that I'm okay kind of 50-50 either way. We can stay and say, go work it out. We can set it for a hearing and kind of see where the chips fall, which again, to me, hypothetically, is going to be in a very similar situation. Go work it out, right? So I think this does bear maybe some discussion with the operators to see if they're amenable to one of those approaches or another.
Thanks, Commissioner Ackerman. I really don't have anything else to add to what has been stated. I am of the same mind that we really are looking for what is the most productive way forward here, and it does seem like either a stay or proceeding to a hearing with all of the potential outcomes on the table are at play here. I'm in agreement with checking in to see if there are thoughts from the attorneys for these parties in light of hearing these deliberative comments. So maybe we can elevate them here to join us.
One moment, please. We're elevating the parties.
Yeah, and just to be clear, this is for questions only. And thanks, Ms. Jost and Mr. Perchala, for joining us. Does any commissioner have a specific question they want to ask or pose, or I may just offer, I guess, ask the question of what their response is to hearing these deliberations, and if specifically if they would be amenable to a stay in this case, knowing that the other potential outcome would be a hearing where all potential outcomes are on the table, including hypothetically an outcome where the commission would find that neither of the applications is approvable, or excuse me, that both must be denied. So I guess that is the question on the table as I would frame it. So let's see. Mr. Prochala, I guess as the party with the motion here, I'll let you go first. And you're on mute.
Thank you. Thank you, Commissioner Oates, for the question. Listening to the deliberations, I think there's a little bit of a disconnect in the concept of precedent, and we addressed this in our reply brief, is that yes, all applications need to be reviewed independently on their own merits, right? We understand that. However, there's also legal precedent that was established in the prior matter, and that's separate from the facts and circumstances that, to the extent that the prior matters were unique, and these matters are unique. There are unique facts. However, the legal precedent still was established in the prior hearing, which is.
Mr. Prochala, I might interrupt you here. That wasn't our question, and I think you're straying into arguing your case here.
Well, no, I was just trying to get to a understanding of where we're at and why. We understand that where you're at now is, do you want to stay or do you want a hearing? I think that's what you're essentially asking us. And what I'm trying to get to the point of is that why I think the stay is appropriate, because the legal question none of the commissioners really address is in what was determined previously is that there is no authority to resolve competing applications. So I think what the commission is really struggling with is that, if we set a hearing, if you still find that the act and the rules don't allow you to choose one over the other, if I understand correctly, you're saying that then you're left with no other decision than to deny both. I don't necessarily agree with that, but from the purposes of Verdad, and I think as you saw in the previous matter, that Verdad is the party that on its own voluntarily figured out a way to get something resolved. There wasn't a deal between the two parties that resolved it. It was Verdad deciding, you know what, let's just get out of each other's hair and we'll amend our application in order to lift that stay. Verdad is committed to working with other operators, its working interest partners. And, in this case here, there have been some discussions. It's been a few months now. But if the commission is inclined to go with a stay, Verdad is amenable to a stay. We think probably 6 months is probably appropriate. Give enough time to try to resolve this. And if we can't, then we'll set this matter for hearing, because we do think that our development plan is better than the Red Hawk plan. It uses an existing location. It fully encompasses the lands in both parties' applications. So we think that, if you're going to look at the two competing plans at a hearing, we're confident in our position, but we're happy to do a stay, and we would propose 6 months.
Okay, thank you, Ms. Jost.
Yeah, thank you, Commissioner Oath. I'm going to answer your question directly. We are not open for a stay. We are ready for hearing, and let me tell you why. This has been stayed. It's been stayed since August 11th, since the date the petition was filed. So we are 4.5 months into this with no business resolution. The parties have been in discussions, and it has not happened. We have 9 reasons in our brief, our response brief. I'm not going to argue those because that's not what your question was. Red Hawk is ready to go to hearing. It requests a hearing in Q1 of 2026. We do not believe a stay will resolve this matter at this point in time. They're more than willing to continue to work with Verdad, but can do that concurrently in preparation for a contested hearing under your jurisdictional authority. Thank you.
Thank you. Commissioners, any follow-up questions? Okay, thank you, Mr. Prochala and Ms. Jost. Commissioners, I guess this leaves us for further deliberations. Commissioner Messner.
Thank you, Madam Chair. Having heard those responses to your question, and I appreciate you posing the question. Couple of thoughts. I think important to clarify that the previous determination by this commission was that there was nothing in the act or the rules that would allow the commission to resolve this dispute between the two applicants. That speaks nothing to any particular authority or not. However, as it doesn't appear that these applicants are interested in both agreeing to a stay, then I would move that we deny the stay application that's before us today, and request that the hearing officer convene the two parties in order to schedule this for a contested hearing at some point in the future.
Thanks. Any additional thoughts? Okay. Anyone care to make a motion?
I think I just did.
AAG Boudreau.
Thank you, Madam Chair. I would also note that one of Verdad's requests for relief was consolidation of the two matters, and I don't think that's resolved. It's my understanding that Red Hawk, in their answer brief, consented to the consolidation. So I would just recommend that that be added to the motion, that the consolidation be granted, and then also Commissioner Messner's, tack that onto Commissioner Messner's motion.
Okay.
I amend my motion to include the consolidation that AAG Boudreau just indicated.
Okay, very good.
Second.
We have a motion and a second. Any additional comments? All those in favor?
Aye.
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 Any opposed? Motion carries 4-0. Okay, thank you all for that. The next matter on our agenda is a second executive session, and this is to receive legal advice on the following matter on our docket, which is a motion for post-trial relief in docket number 240900228. AAG Davenport.
Thank you, Madam Chair. As noted in the agenda, and I'll read a brief script, the Commission is entitled to go into executive session as authorized by CRS Section 2464023A Roman 2 to receive legal advice and analysis on the Frederick and Dacono motion for post-trial relief in the docket that you previously mentioned. I would encourage a motion to go into executive session for those purposes. And for the record, I would note that for this matter and this matter alone, that AAG Boudreau, as staff's counsel, will not be participating in the executive session.
Thank you. I will move that we go into executive session.
Second.
Thank you. All those in favor? Aye. Any opposed? Thank you. Motion carries 4-0. We will go into executive session as before. It's hard to note how long until we are able to return, but please stay on the line and we will return when we are concluded with our executive session. Okay, we are back from executive session. AAG Davenport.
Thank you, Madam Chair. The Commission is exiting executive session, which the Commission went into for the purposes authorized by open meetings law to receive legal advice and analysis on Frederick and Dacono's motion for post-trial relief in docket number 240900228. The Commission received that legal advice. The Commission did not deliberate or vote. And again, I would note for the record that AAG Ben Boudreau did not participate or attend that executive session. Madam Chair, we now need a motion to exit executive session.
Thank you.
So moved. Second.
Thank you. We have a motion and a second. All in favor?
Aye.
Aye. Any opposed? Motion carries 4-0. Thanks all. That brings us to Commission deliberation on the City of Dacono and Town of Frederick's motion for post-trial relief in docket number 240900228. I may actually take the liberty of starting us off here on deliberations. I think on this one, I would note that the Commission has accepted motions for reconsideration in the past, and I see the city's motion for post-trial relief as similar to those previously accepted motions for reconsideration in other matters. But here I view the city's arguments as a mixture of arguments that the Commission misapplied its own rules, as well as attempts to re-argue the case or convince the Commission to change its mind. I think a motion for reconsideration is not appropriate to re-argue a case, but the cities did argue that the commission committed a legal error, and we must consider the substance of the legal arguments that were raised in the motion. I mean, ultimately, I'll say, in my view, the city's motion was not persuasive to me. I read the cities to raise 3 arguments. I will address those arguments, but in a different order than were presented in the city's motion. First, I do not believe that the commission misinterpreted the used or useful definition. The cities concede that this issue may not be necessary. This was on page 8 of their reply, stating that the commission order may only need clarification. So I will, in response, will provide that clarification. The commission may order an operator to plug and abandon a well that is producing more than nothing if an applicant demonstrates that the well is not useful. The commission did not intend to create a loophole that would allow an operator to avoid plugging and abandoning a not useful well by producing some small amount of oil or gas. Second, I do not see that the commission committed any error in its consideration of the evidence at hearing or in deliberations. The cities argue that the commission failed to consider plugging, abandonment, remediation, and reclamation costs at the hearing. The order reflects that a majority of the commissioners concluded that the cities failed to meet their burden because the city's economic evaluation of the wells at issue was incomplete and unreliable. And without reliable evidence regarding the value of the wells at issue, there was nothing to compare against closure costs. Regardless, the record of deliberations reflects the commissioners who voted in the majority considered closing costs. So if one commissioner states a rationale during deliberations and other commissioners agree, there is no legal requirement for the other commissioners to repeat that rationale. Similarly, there was no legal requirement for the commissioners to deliberate on each well individually, as the majority found that cities failed to meet their burden for the same reason for every well at issue. So it would have been inefficient and frankly pointless for the commission to repeat the identical rationale, motion, and vote for each well. For the 3 wells that the commission ordered KPK to close, it considered each well individually because it anticipated that the vote count might be different for one or more of those wells. The order reflects the vote was different for one well than it was for the other 2. The commission's motion and voting process was more than sufficient because it reflected the positions of each commissioner accurately. Cities argue that because the commission considered KPK's evidence of value for the 3 wells, it ordered KPK to plug and abandon, that the commission should have compared KPK's evidence of value to closure costs for the remaining wells. This argument, I find, ignores the burden of proof, ignores that the commission considered all evidence in the record for all wells, and amounts to a disagreement with the commission's conclusions rather than legal error. So I would be supportive of a motion to deny the city's motion in this case. Other commissioners with thoughts? Commissioner Cross.
I'll just say I think you're spot on, and I would, if you did not make a motion, I will make a motion. If you did, I will second it.
Well, I'll take that as a motion from you. I was just sort of noting for comments that was where I'm at. So sorry for not being clear, and I appreciate it, Commissioner Cross. Thanks, Commissioner Messner.
Thanks, Madam Chair. I think that it's important to note the request for reconsideration or new deliberations in this particular instance is unique to the determination of the contested hearing itself. And so, in my opinion, there's 2-3 different things that are being contemplated here. 2 legal errors, alleged legal errors, and 1 alleged procedural error. And so those are the things that I'm looking at in this particular instance. In my opinion, different commissioners necessarily, because of the different seats that we hold and the different backgrounds that we have and the different expertises that we have, may interpret rules in different ways, especially rules that may be slightly ambiguous, and may deliberate in different ways as they work through the different aspects of the case that's before them. And I don't know if there's a particular requirement in our rules or in the APA on how this commission needs to deliberate. I do think that it is important that this commission provides clarity in the ultimate rationale for what the outcome of those deliberations may entail. I think we're always improving on our clarity and how we determine through our deliberations what our ultimate findings are and how we came to the conclusions that we came to. And I think this was a unique situation where the application of used and useful on a very broad and grand scale, with a large number of wells associated with this, did create a deliberative challenge to this commission because of the volume of wells that were brought at once before this commission. And I think each of the commissioners chose maybe a little different path on how they were going to deliberate on this, but I do believe that all the commissioners took all of the information necessary in from the proceedings and utilized their judgment in determining how they were going to interpret the rule and ultimately develop the findings that they thought were necessary in order to come to the conclusions that they did. And this was not unanimous, which does show that we all looked at it and maybe interpreted the application of the rules slightly differently. But nonetheless, the majority did agree on a certain findings and a certain path forward that I didn't find any particular legal error with, nor procedural error with. And so I would agree, Madam Chair and Commissioner Cross, and would second Commissioner Cross's motion.
Commissioner Ackerman.
Thanks. I don't have a whole lot to add. I appreciated your thoughts, Madam Chair. I also had some individual points, but they were stated more eloquently by you. I would just state also that I don't believe there were any errors in finding of fact or conclusions of law. And just a reminder that the statement of basis and purpose on this specific rule that allows for the ordering of closures reminds us that we rarely do this to plug and abandon wells, as there are other remedies that we often seek to ensure that wells are operating safely and that wells have a closure plan. And we explicitly state that we continue exercising discretion under the rule, and only in rare instances where doing so is necessary do we enact this rule. I think that was made clear during the hearing, but bears repeating here today, along with the other points that were made. And I'm in agreement with the thoughts that have been set forth here. And also appreciate Commissioner Messner kind of setting forth a little bit of how we make the sausage as we go. It's not an exact science, but we do come to very precise conclusions based on our interpretations, and I think we've done so appropriately here.
Thank you. So we have a motion that has been seconded. All of those in favor? Aye.
Aye.
Any opposed? Motion carries 4-0. Okay, so that brings us to the next matter, which is oral argument, which has been granted in docket number 240800190. So let's go ahead and elevate the attorneys for these parties and begin with entries of appearance. Okay, I'm seeing a number of folks joining us here on the screen. Let's begin with appearances for the applicant, Verdad.
Good morning, Commissioners. Thank you for your time. For the record, my name is Michael Jewell Jemerson Natural Resources Law, on behalf of Verdad Resources, LLC.
Good morning, Christine Wendell, also with Jemerson Natural Resources Law, and also for Verdad Resources, LLC.
Great, thank you. And entries of appearance for Civitas.
Good morning, Melinda Moraine with the law firm of Beatty and Wozniak on behalf of Civitas North, LLC.
Ryan McKee, also with Beatty and Wozniak on behalf of Civitas North, LLC.
And we have a Ryan Gores. You're on mute, Mr. Gores.
Yeah, good morning, Ryan Garris with King Operating.
I'm sorry, with whom?
Yeah, King Operating, I think they made an error when they asked me to join as a panelist here.
Got you. Thank you, Mr. Garris.
Apologies. We'll de-elevate Mr. Garris.
Thanks, Hearings Manager Thomas. Appreciate it. Okay, so we are here for oral argument. Each of the parties has 10 minutes. We are going to start with Civitas, followed by Verdad, followed by any party that may have remaining time and desires to provide rebuttal. Commissioners may have questions, and I will turn it over to Civitas here to begin.
Thank you, Commissioners. Again, Melinda Moraine with Beatty and Wozniak for Civitas North. I know the Commission indicated they have everything they need from our paper, so I just want to make a few points, and then I'll reserve about 2 minutes of my time for rebuttal. Civitas North respectfully requests that the Commission not adopt the hearing officer's recommended order. The recommended order denied Civitas North's petition because the order incorrectly determined that Verdad's unsuccessful delivery of its May 2nd, 2024 offer constituted actual receipt of an offer to participate that triggered Civitas North's minimum 60-day period to respond. Even ignoring that error, if we assume that Verdad's unsuccessful delivery did trigger that 60-day period, Verdad, having actual knowledge that Civitas North did not receive their offer, had a duty to act in good faith according to industry standard in accepting Civitas North's acceptance of the offer on July 30th. Now, I'll presume the Commission is familiar with the facts, but there are 2 factual points that I want to make. First is that the offer was not sent via the U.S. Postal Service. Courts and the proposed order provide a certain presumption of delivery when it relates to the U.S. Postal Service. The law does not afford that same presumption of delivery to private couriers such as FedEx, DHL, or UPS. And Verdad and the proposed order do not cite any authority for applying that presumption to a private carrier service. That accounts for this very situation where presumably a FedEx driver unable to make actual delivery signs with the name of the company, see Civitas, and leaves it somewhere. Second factual point that I'd like to point out is that Verdad had actual knowledge of this non-delivery. If good faith means anything, it should mean that an operator is not allowed to profit from the failure of its own choice of a delivery service, and then upon receiving notice that its choice of delivery service failed, wait out the 60-day period to respond to the inquiry such that the time has expired. Now, I'd like to clarify, Civitas North is not implying that Verdad or Mr. Berghorn acted in bad faith by being out of the office on July 2nd or failing to respond to Ms. Jenkins' email while he was out of the office. What Civitas North is asserting is that after having actual knowledge via Ms. Jenkins' July 2nd email of that non-delivery, that the duty of good faith encompassed in Rule 506 warranted an inquiry into that non-delivery and a good faith attempt to effect that delivery and provide the 60-day period offered to the other parties in this case. Ms. Jenkins did not receive a response from Verdad to her July 2nd email until she followed up on July 8th, at which point Verdad denied Civitas North the opportunity to participate. Now, moving on to 2 legal points. Rule 506 requires receipt of an offer to participate. The language is receiving an offer to participate in 506C, not service, not sending. The Commission could have used the word delivery or mailing or service, but it specifically chose to use the word receiving. Thus, the proposed order's finding that 506 does not require ensuring receipt is atextual and unsupported by the plain language of 506. This makes inherent sense. While the Commission is currently considering a case with a sophisticated party like Civitas North, this case will presumably set the precedent for non-sophisticated parties going forward, allowing the sender, the operator, to both choose the method of delivery and to suffer none of the consequences when their choice of a method of delivery fails. Second legal point, Rule 506 requires Verdad to have acted in good faith. Therefore, once Verdad had actual notice of non-delivery, that actual knowledge being Ms. Jenkins' email on July 2nd, they had a duty to act in good faith. What is good faith? The observance of reasonable commercial standards of fair dealing in oil and gas operations, and to, quote, honestly and faithfully comply with its duty to provide that 60-day notice. Civitas North had a reasonable expectation that it would receive notice of the offer and 60 days to respond. Verdad's failure to provide the offer and failure to respond once it knew it didn't actually affect delivery was unreasonable and inconsistent with industry standard and practice. If, as the proposed order found, all that's required under Rule 506 is that statutory 60 days, then that renders the good faith language in that rule effectively meaningless. Finally, the proposed order erred in construing this commission's discretion too narrowly. The plain language of Rule 506 clearly provides this commission with discretion through use of the term may. The commission should exercise its discretion to deem Civitas North a consenting party. Finally, I'm happy to address the allegations that Civitas North does not have standing if there are any questions from the commissioners. But as evidenced by Ms. Jenkins' declaration in our reply, Civitas North continues to have a financial interest in the outcome of their protest, as it will unquestionably impact the value of the asset they sold. I don't see that Rule 507 contains a continuing obligation to update that interest, but if it does contain that obligation, that is on me as Civitas North's counsel, and happy to do that for our clients in the future. If the commissioners have no questions, I will reserve a little time for rebuttal.
I was planning, Commissioner Messner.
Madam Chair, if you want us to wait till the end, that's fine.
Well, I was going to wait until the end just so we can hear the parties out, but I'm happy to also allow questions now if you prefer.
Wait till the end. That's fine.
Okay. All right. Thanks, Ms. Moraine. Mr. Jewell?
Thank you, Madam Chair. Commissioners, good morning. Thank you for your time today. And again, for the record, my name is Michael Jewell, Jimerson Natural Resources Law, on behalf of the applicant, Verdad Resources, LLC. I'll make this brief because I'm sure, as is custom in these hearings, as we've done many times before, the pleadings have been reviewed and the merits stand on their own. Based on the exhaustive evidence briefed multiple times over, presented at hearings before Hearings Officer Berman, and reviewed thoroughly by ECMC staff, Verdad requests the Commission reach the same conclusion as did Hearings Officer Berman, and that is that Verdad followed all the ECMC rules in providing proper notice to interested parties in his pooling application and correctly considered Civitas North as a non-consenting party. To that end, I'll just quickly recap 6 main points and reserve about a minute for any potential rebuttal. In this matter, Hearings Officer Berman correctly determined, number 1, late or conditional elections to participate in a proposed well under the Act and Commission rules must be construed as a decision to decline to participate in the wells. Neither the statute nor rules contemplate a conditional election of any kind. Number 2, as mandated by Rule 504, Verdad serves Civitas North with a notice of application, an election letter, and an offer to participate in Civitas North's address on record via FedEx, as evidenced by the tracking receipt. The record also shows that Civitas North accepted notices via FedEx on several Fridays afternoon, the timing that was at issue, with no issue whatsoever. Number 3, you commissioners have already determined that delivery via FedEx satisfies the receipt requirement before this matter in docket number 1904-00289, which is now memorialized under ECMC order 407-3298. In that case, undisputed evidence that a parcel was sent satisfied the receipt requirement under the statute and rules. In this docket number 2408-00190, Civitas North did not dispute Verdad's evidence that the package was sent by FedEx nor the authenticity of the tracking document. Number 4, Verdad's failure to respond to Civitas North's email, which did not include an election preference, for 6 days over holiday weekend was not a failure of Verdad to act, quote, in good faith, unquote. Number 5, mineral leasehold owners are either consenting or non-consenting. Consenting owners can only be those who voluntarily agree to participate. Non-consenting owners are everyone else. Lastly, number 6, the Commission has an implied obligation to implement the rules surrounding the 60-day consent period to determine whether a party is deemed consenting or non-consenting. To find otherwise would be to invite an arbitrary decision. And I'm not sure we want to get into the weeds of standing. We can certainly do that on rebuttal or with your questions, but suffice to say, you were not notified that there was a change in ownership, and it seems that their remaining interest is a contractual and merely financial one, not one that runs under the land in your jurisdiction. So with that, I will I will pause and thank you for your time.
Thank you, Mr. Jewell. And Hearings Manager Thomas, I did not note at the start a request to, or I guess a verification that you were keeping time tracking. I'm hopeful that that was the case, and maybe you can just let us know what amount of time remains for each of the parties.
That is the case, Madam Chair. Counsel for Civitas has 4 minutes and 18 seconds remaining. Counsel for Verdad has 6 minutes and 54 seconds remaining, so plenty of time for rebuttal.
Thank you. I appreciate it. Okay, Ms. Marie, do you have rebuttal testimony?
Thank you. I don't need any rebuttal at this time. I think I covered all the issues.
Okay, thank you. Mr. Jewell?
We likewise will rest. Thank you.
Okay. Commissioners, questions for the parties? Commissioner Messner, you had raised your hand previously, so happy to start with you.
Thanks, Madam Chair. Ms. Moraine, help me understand with your interpretation of the rule and the term receiving, how an operator would have to comply short of having each of these served.
Have them served personally? Is that your question?
Yes.
I think there are ways where parties did not dispute receipt or where there wasn't a question of receipt. I think this is a pretty limited case in which there was actual knowledge of non-receipt here, which triggered that additional duty to make sure that there was a receipt. The commission and the parties regularly use the U.S. Postal Service with a green card that ensures actual delivery in that case. So I think that the parties or that operators are allowed to rely on any method of deceit or of receipt, pardon, not deceit, but that then they bear the risk if that's not an effective delivery service.
So having been involved in hundreds and hundreds of land use cases that all require some notice, and in many jurisdictions that I've worked with, that notice is required through certified mail specifically. But there are many instances where even through certified mail that it may be determined to be undeliverable. How does that play into your interpretation of receiving?
You're creating a hypothetical essentially that what happens if it's undeliverable?
Sure.
Sure, whether they
You're working off of some address that you may or may not know the accuracy of, some may come back as undeliverable. How do you resolve your interpretation of receiving in that situation?
So I think, to the extent that a party disputes that they actually received it, I think that a operator would have to basically take on the burden of showing that they had attempted a delivery and that delivery, was essentially received. I think in that case, if a party is appearing in the case, they have received it. For example, the statute provides 3460-108 section 4 talks about ways in which the commission affects delivery. And in that instance, the U.S. Postal Service delivery is presumed if you also do a publication in the newspaper, right? There's checks and balances here. That could be presumed to have done receipt. Those checks and balances, however, were not met specifically in this case.
Okay, thanks.
Additional questions by commissioners? Yes, Commissioner Cross.
Thank you, Madam Chair. Mr. Jewell, I have a quick question. You did note that there was other deliveries made to Civitas on that Friday. Do you know what the signatures were on those receipts?
Thank you, Commissioner Cross. And to be sure, it was another unrelated FedEx delivery, I believe a few weeks subsequent. But the salient facts there was that it was received on a Friday afternoon, where the record shows that Civitas North says they are closed and unavailable to receive such notices. And I do not recall or could read what that signature was. We could probably find it. I think it's in the record, actually.
Okay, so in this instance, somebody did sign for it on that afternoon under this C Civitas, but on another Friday, they said they're not open for deliveries at that time.
And no, sir, they said they were, as part of this proceeding, that they would not be open past 12 noon. But we introduced evidence that indicated to the contrary, that whether or not they were open, someone was receiving, and they did not object to that receipt at that time.
Okay. And I think it's probably helpful for everyone listening in to understand this as well. But can you go into a little bit what the difference would be with Civitas North, obviously standing issues aside, being a participating versus non-participating in this? Well,
Is that, just to be clear, is that a question for both of us or just for me?
uh, we can have you answer it first, and I guess if Ms. Moran has any disagreement, we can hash that out. But
Just want to be sure. Thank you, sir. The position of Verdad that we presented at hearing was consistency, that there are multiple parties who needed to elect or be leased, but that's outside the scope here. And those arrangements are made on the 60-day time frame so that all parties can be certain as to what the financials are going to look like. And we treated Civitas North in no different way than we would treat any other owner or how we treated them at any other time, and frankly, vice versa.
understood, but could you go into what effects on, because you talked about the financials with respect to the other owners as well, but can you go into what the participating versus non-participating means and why that's important for Verdad to do so?
Oh, sure. Well, if they're a non-participating party and the subsequent pooling application is approved, then they would be subject to the pooling penalty. And that's a financial decision that reeks on one party or the other, but for Verdad's purposes, again, for planning, consistency, and fairness for all.
Okay. Thank you. Those are my only questions.
Ms. Moran, did you care to respond?
Yes, just to respond to Commissioner Cross's question. Obviously, there is a financial benefit to Verdad if they are able to designate Civitas North as a non-participating party, and a financial detriment to Civitas North if they are designated non-consenting as opposed to consenting in this well.
Thanks. Any additional questions? Okay, I'm not seeing any. Thank you for your oral arguments and responses to commissioner questions. Let's, commissioners, move into deliberations. Would any commissioner care to start us out? Thank you, Commissioner Cross.
So I'll be honest, I think this is a bit of an oddity. And in that, I think that, when you specifically look at Rule 506 and the involuntary pooling applications, it talks about receiving evidence that the owners were tendered a good faith, reasonable offer to lease or participate. And to me, I think one of the things that sticks out is there are instances where, as Commissioner Messner noted in his question as well, that certified mail is usually required. That's not something that's required here. I don't think that using FedEx would be any indication that FedEx is improper. We very clearly can, and in other instances do say when certified mail is required. So I don't think that using FedEx is a failure to provide good faith, reasonable offer to lease or to participate. I think that it's a little awkward here that a party would receive a signature that is clearly not the signature of the company, and just say, well, clearly they received it and did it. But at the same time, I think it's a little bit of an oddity to say that the method itself was not a good faith method. I think that I don't know. I'll be honest. I think that my initial indication is we should probably not penalize someone who quickly after the fact gives an indication that they did not receive anything, and I think that at the same time, it's a little hard to say, do you have to follow up with people, as was indicated in some of the questioning. I don't think it's a situation where you should have to be like, well, we didn't do this, so we have to now go to the other owners that didn't respond and say, are you sure? Are we double checking? That's not something that's required under the rules. Um, and I guess I'm a little baffled by the fact that there wasn't any kind of leeway given for shortly afterwards trying to say, hey, we never received this. As you look at the receipt notified, it is not Civitas North. It is not someone on behalf of Civitas North. It is C Civitas, which is a little weird. But I would be curious as to what other commissioners think, because at the same time, I don't necessarily believe that using FedEx is not a good faith method or a good faith offer to participate. I I find it a little a little hard to kind of parse that out, because there was clearly something sent. It shows it was sent. I don't think there's a duty to necessarily follow up, but at the same time, I can see how once received notification that they never received it, that there should be at least some consideration of the fact that it was not received, and there was an election made as soon as it was known. But I'd be curious as to what other commissioners think too.
Thanks, Commissioner Cross. Other commissioners with thoughts? Commissioner Messner.
Thanks, Commissioner Cross, for kicking us off. I think this does come down to good faith effort, and I think that I think an interpretation that the U.S. Postal Service is better than FedEx or UPS or whatever is kind of an unreasonable interpretation. I think that in lieu of having specificity on the exact mechanism for the delivery, the standard here is did they make a good faith effort? And I think utilization of FedEx is certainly a good faith effort. I think any expectation that is more than that would be unreasonable and unnecessary to look at, individually hand serving folks these documents versus having a receipt that this in fact was delivered. And I think certified mail and FedEx are equal in that. And so I don't have a problem that a good faith effort was not made, but would agree that it always makes me scratch my head that there's not more congeniality in being able to work this out, when there was an understanding shortly afterwards that that maybe they had not received the documents. And so but at the same time, the question here to me is whether or not a good faith effort was made, and I do think that that was the case.
Commissioner Ackerman.
Yeah, I mean, I think we're all of the same mind here. I head scratching is a nice way to put it. Certainly we try to promote people working together fairly and congenially, right? That's not within our purview to ensure or to assure that people do that. And so it comes down to me is there enough to overturn the hearing officer's order or not approve the hearing officer's order? And I don't think that there is. I think, in Rule 506, it does talk about good faith, observing reasonable commercial standards of fair dealing, and absence of an intent to defraud or seek unconscionable advantage. I don't think that the notice was sent, or there's any evidence that the notice was sent in that way. And so I don't see, for me, really an avenue to overturn the hearing officer's decision, regardless of how there might be, some sourness associated with the way that Verdad handled the announcement that Civitas North had some concerns after the period had expired.
Thanks. I am also largely in agreement. I think I certainly agree that it comes down to good faith for me as well. Agree that the sending of the communication was done appropriately and in good faith. It almost becomes a question of, does it therefore become not good faith when the notice was provided that it didn't actually reach the recipient? And I would agree that it does not seem that it meets the standard and the definition of what is considered good faith, and being unconscionable. So I think I am certainly in alignment with what other commissioners have stated. Commissioner Cross.
Thank you, Madam Chair. I'll just say one other thing that I think is important to note, and I think it's also that it talks about a good faith offer to participate. And Rule 506 also goes into a little bit of what the good faith offer is. It's not really going into the good faith acceptance or the good faith delivery or anything like that. And so I think that's an important thing to note as well. And then finally, I did want to note that I know Mr. Jewell brought up the conditional election, and I don't think that was necessarily a case here where they try to come back with like a counteroffer or any kind of condition on the election or anything like that. I think that's important to note as well. But at least what I'm hearing, I think is agreement amongst us that I think that there was a good faith offer to participate that was sent. Whether or not there was good faith by Verdad here in trying to respond once it was determined that maybe delivery was not appropriately made is another question. But I agree with Commissioner Ackerman as well. I do think that this is a situation where to go against the hearing officer would be a little difficult.
Thank you, commissioners. Ms. Moran, I see that you have your hand up. It's not part of our procedure to allow attorneys to respond to commissioners' deliberations. So rather than allow you to make your point, maybe I'll ask you if you're just trying to make a point after hearing commissioners deliberate, or if there's something else that you would like to say.
There appears to be a factual misstatement. So if I'm allowed to address that, I'd just like to address that.
Okay.
But if not,
why don't you go ahead?
I just wanted to clarify that the notice of non-delivery was received during the 60-day notice. I believe 2 of the commissioners indicated that it was received after that period had expired.
Okay, thank you. Commissioners, with that, if there's anything additional you would want to say in response about your deliberative comments, want to give you an opportunity to do so. Okay, thanks. Okay, commissioners, it sounds like there's a good amount of consensus here. Would any commissioner care to make a motion?
I'll make a motion. I might need a little help in just making sure that I have the right motion. I don't know if it's Mr. Boudreau here.
I think it's AAG Davenport.
AAG Davenport. My motion would be to uphold the hearing officer's decision, but I just want to make sure that that's an appropriate motion.
Thank you, Madam Chair. Thank you, Commissioner Ackerman. Yes, technically this is up on a exception from Civitas, so I think either or both a motion to deny the Civitas exception and uphold the commissioner's, or excuse me, the hearing officer's order would be sufficient.
Thank you. I'll make a motion then to uphold the hearing officer's decision.
I will second that. And all in favor? Aye.
Aye.
Any opposed? Motion carries 4-0. Thank you.
Commissioners.
Okay, commissioners. I think it's 11:15. I think, especially considering that we may have inclement weather coming in here, I'm inclined to take a bit of a short break, but then proceed with our last docket matter for the day. So let's see, it is 11:14. Why don't we return at 11:24 and proceed with the next matter? Okay, we are back. And next on the agenda is a request for a variance in docket number 250600107. We will begin with a presentation by the applicant Wellington Operating Company. We will begin with swearing in of witnesses. Mr. Carney, do we have everyone that we need?
We do.
Mr. Chapman, thank you. Okay. AAG Davenport.
Thank you, and I apologize. Who am I swearing in?
Well, I am an attorney testifying on behalf of Wellington, but Mr. Garris is our potential panelist / witness.
Okay. Ms. Chapman, so as I understand it, you are a witness rather than an attorney representing
Okay.
the applicant? Okay. So, I'd ask each of you then to raise your hand, state your name, and state that you swear to tell the truth. Mr. Garris, why don't you go first?
Ryan Garris, I swear to tell the truth.
Thank you. And Mr. Chapman?
My name is Zach Chapman, and I swear to tell the truth.
Thank you.
Great, thank you. All right, please proceed.
Good morning. Still is, commissioners. As stated, I am Zachary Chapman, attorney registration number 43695. I also have my colleague Scott Carney, registration number 44025, joining us. We are a part of Carney McWilliams and Davis, and we are here on behalf of applicant Wellington Operating Company, operator ID 95233. As part of our witnesses, we do have Ryan Garris. He is the executive vice president and engineer. He provides production engineering and management oversight for Wellington Operating. And we are here on our application for a variance from Rules 903 as they relate to certain lands located in Larimer County, Colorado. I guess one quick question. I know that I provided my presentation. Will it pop up? Do I need to somehow take control or?
Mr. Chapman, we can run the presentation on your behalf, or you're free to share your screen and operate the presentation yourself. What would you prefer?
It does not matter to me. I can drive if you want. They go pretty sequential, although I do have to backtrack once.
I would recommend you drive then for expediency purposes.
No problem. So share screen. Sorry, this is kind of new to me here. I haven't done this one before. Oh. It says that my share screen is disabled.
Let's see if we can fix that on our end.
Apologies, we'll fix that one moment.
Thanks.
Okay, Mr. Chapman, please try again.
All right, we can see that, Mr. Chapman.
Perfect. Can you still see it?
Yes, it was in presentation mode, and now it is not.
All right, kind of takes over my whole screen here, which I guess probably makes sense. I have two screens here. I was hoping to keep the video up so I could see you guys while I was speaking.
Yeah, it does. Indeed, it will mean that you cannot see us while you're presenting.
All right, well, then I will proceed if you guys are ready.
We are, thank you.
Thank you very much. As stated before, we're here on our application to allow a variance from Rules 903 as they relate to certain lands in Larimer County, Colorado. The lands are located in Larimer County. The North Battery is located in Section 6, and the South Tank Battery is located in Section 7, as seen here. Just as a little bit of procedural timeline, King Operating acquired Wellington and these lands and properties on March 1st, 2021. Since acquisition, Wellington's work in the field has been focused on bringing the field in compliance with local and state operations, modernizing the field, profitability, and utility in the field, as well as maximizing utilization of produced gas. This cause matter was previously heard on June 2024. At that point in time, there was a director's recommendation to approve our initial variance based on the reasonability of the request. Ultimately, the variance was granted in 2024. This approval came with a clear message. Do not come back in a year requesting a temporary extension of the variance without having shown at the very least attempts at better utilization of the gas or some offset of the environmental impact. Wellington understood this message and comes before the commission with substantial progress made in both. We filed our application on June 17th, 2025 for this extension of a temporary variance. We submitted an amended application on August 7th, which was done just to correct and update the status of the wells. And ultimately, we did notice as required. It was distributed to all required parties, the application and the notice of hearing on August 18th, 2025. Contemporaneously, we also caused the language of the notice of hearing to be published in 2 newspapers, one circulating in Denver and the other circulating in Larimer County on August 21st, 2025, and running for 5 consecutive weeks. In total, all necessary parties have been noticed. And on 12/3/2025, we received the director's recommendation for this variance request. Ultimately, the staff has based our analysis, and I'll highlight these here, on the reasonability of the request and based on the relative value of the mineral lost to flaring as compared to the value of the mineral sold. The requested 2 facilities have gas to liquid ratios ranging from 15 to 664 standard cubic feet of gas per barrel with an overall average of 69. They noted that given the depleted reservoir, the use of the water flood enhanced recovery technique is necessary to continue to produce the residual oil. Further, the requested 2 facilities have oil to gas ratios ranging from 2148 to 5764. The ECMC defines a gas well as having a gas to oil ratio of 15,000 or more, and these facilities combined have an overall average of 4,044. The GORs associated with the facilities subject to this request reasonably support an argument that the lost value of the produced gas is relatively minor compared to value of produced liquid. And ultimately, the staff does agree that the volume of gas being emitted post-combustion, utilizing the enclosed combustion with 98% destruction efficiency and control of all associated emissions is de minimis and unlikely to have a significant adverse impacts to public health, safety, welfare, the environment, and wildlife resources. Ultimately, we're looking here at 502C. The operator or the applicant is requesting the variance and must show that it has made good faith efforts to comply or is unable to comply with the specific requirements contained in the commission's rule or order from which it seeks a variance, including without limitation securing a waiver or an exception. We must also show that the requested variance will not violate the basic intent of the act. The requested variance is necessary to avoid undue hardship. Granting the variance will result in no net adverse impact to public health, safety, welfare, the environment, or wildlife resources. And finally, the requested variance contains reasonable conditions of approval or other mitigation measures to avoid, minimize, or mitigate adverse impacts to public health, safety, welfare, the environment, and wildlife resources. Wellington has made a good faith effort to comply or is unable to comply with specific requirements contained in the commission's rule or order from which it seeks the variance. As far as utilization goes, there's a high utilization of gas in the field with 7 domestic gas taps, 2 farm taps operating power irrigation well pumps, 8 field-fired gas engines operating pump jacks, and a gas-fired heater. Emission control devices installed in the fields, 1 in each. Wellington has taken strides in increasing the utilization of produced gas and reduced the amount it combusts. The message of the commission at the conclusion of last variance did not fall on deaf ears. Prior to the granting of the previous variance, Wellington was producing 26,640 cubic feet of natural gas in their north field from April 2023 to April 2024. They were utilizing 16,076 cubic feet and combusting 10,564 for an aggregate utilization of 60.3%. In the south field, they produced 17,196 cubic feet with utilizing 13,985 and combusting 3,211 for an aggregate there of 81.3%, as can be seen. Ultimately, the utilization rate across both fields was 68.6%. Since the variance was granted in the period of May 24 to April 2025, the production of natural gas has remained nearly the same. In the north field, they continued to produce 23,305 cubic feet, utilized 14,522, and combusted less at 8,783 for an aggregate utilization of 62.3, an increase in utility of 2%. In the south field, they produced 16,000 cubic feet, utilizing 14,963 and combusting 1,574, which is half of what they combusted in the previous year. This aggregate utilization of 90.5%, an increase of 9%. The utilization rate across both fields has increased to 74%. In total, Wellington has remained steady in their production, increased utilization across both fields by 5.4%, and as a byproduct of that, decreased the amount combusted by 5.4%, equaling a nearly 11% change across both fields. Wellington is still unable to connect to any existing natural gas gathering services. 502C, we have to look at C2. The request does not violate the basic intent of the act. Granting the variance, will not have an adverse reaction and will not violate the basic intent of the act. The commission is required to foster the development of oil and gas resources, protecting and enforcing the rights of owners and producers, and in doing so, prevent and mitigate significant adverse environmental impacts to the extent necessary to protect public health, safety, and welfare, but only after taking into consideration cost effectiveness and technical feasibility. In short, the implicit intent is to permit each oil and gas pool in Colorado to produce up to its maximum efficient rate of production without harming public health, safety, and welfare. Ultimately, 50C3, the undue hardship requirement, the request variance is necessary to avoid an undue hardship. No production during the shut-in period, if it was to be shut in, and reduced production several months afterwards. In addition, lost revenue for the royalty and working interest owners during these periods of shut-in and reduced production. And lastly, operational and equipment costs posed by not only shutting in, but also bringing the field back into production after a shut-in period. In short, there's a small amount combusted over a short period of time the variance is requested, and it's unlikely to result in a negative impact. The addition of natural gas flow lines will continue to increase the utilization of the produced gas in the fields, both the north and the south fields, as can be seen here on the screen. The Wellington also included 800 new feet of section of gas flow line for additional utilization. Additionally, Wellington has adverse impact partially offset by the development and use of a novel water resource, as discussed in more detail in the provided written testimony of Mr. Garris. Wellington completed the plant for this water flow line and is currently able to run it. However, it does cost a significant amount to run, but we do not have someone to use that water as of yet. Wellington is not opposed to the cost when a viable user is available, but currently there is not one. Wellington is preserving the water by injecting much of it back into the aquifer. The water that has been repurposed is equal to a 15-year supply of water that has been created in this aquifer, and that's based on the hydrological study that Wellington had completed. Wellington has also taken the next steps and hired a water broker. They are actively seeking out an appropriate connection that can use the water so the deal can be made for the said water. And once the broker locates a viable source of the water, a contract can be signed. The water plant can be immediately turned back on if it's needed to be turned back on, and this novel 15-year supply of water can be utilized. The water production is dependent on oil production. Without a variance, the production of oil ceases, which in turn ceases any real potential for this novel water source. Lastly, the applicant will take any necessary steps to avoid, minimize, or mitigate adverse impacts. The requested variance for a short but specific duration avoids concerns the Commission has raised in past about open-end timeframes for a variance of this nature being excessive and unreasonable. Additionally, the emissions from the ECDs are subject to monitoring and reporting and has set limits on the amount and types of emissions. And lastly, the novel water source is a mitigation on the adverse impacts of production and combustion. Lastly, the applicant respectfully requests that pursuant to Rule 502A, the Commission grant the requested variance and enter an order providing a 12-month for the application, a 12-month for the application lands and facilities from Rules 903 to allow applicant appropriate opportunity to evaluate and implement beneficial uses for the produced gas while allowing the Wellington field to remain economically viable in its ongoing production of oil. Thank you.
Okay, thank you, Mr. Chapman. And if you want to stop screen sharing so that you can see us, that would be fine. Commissioners, questions for the applicant? Commissioner Cross.
Thank you, Madam Chair. I want to ask a couple questions. The first is, as you talk about your good faith efforts to comply and the domestic gas taps, the irrigation pumps, etc., are all of those new utilizations of the gas in the area, or is it just built on?
I believe. Go ahead.
So the domestic taps are not new. They've been in place for quite some time. The newest use that we implemented in the last 12 months was the addition of the gas flow lines that effectively tie the north and the south batteries together so that we can more effectively move the gas to where we need it, to where it can be used. And that's what's increased the gas utilization and reduced the combusting over the last 12 months.
And so the flow line maps, and it says as planned and to be constructed. What on there is constructed and being used right now, and what is planned?
I believe actually all of that has been constructed. I think that's a typo on the slide that it says to be constructed. I think that should have been updated to say newly constructed.
That is my error.
Okay. And so big picture is was the heater being used before? Were the irrigation pumps being used before?
So the heater was used before, the irrigation pumps were used before. The issue was that in the winter, when our gas production would drop off some and our demand at the heater would increase, we would sometimes starve for gas on the south side of the field and have to power pump jacks. And it was also true on the north end, but more to the point of using more gas, we would have to either power those with propane or we would have to shut the wells in for a matter of days or something like that. Not long periods of time, but maybe a couple weeks, few days. By connecting everything together, then the north end of the field where there was surplus gas could be utilized in the south end, and the wells on the south end that made more gas we could effectively distribute out to other wells and then use the gas that already existed in the field instead of powering them on propane or having to shut them in.
Okay, so in the last year, you've built these flow lines, which has allowed you to be a little bit more efficient in your uses, but there hasn't been any really new uses.
No, there are no actual new uses, just being able to use more of the product more efficiently.
And in the last year, you've had the two ECDs permitted, or were those permitted before 2024?
Those were previously permitted. They've been inspected this year, but not newly permitted.
Okay. So I guess the biggest question I have is moving forward, you're asking for another 12-month extension. What are you hoping to do to further utilize or better utilize the gas so it doesn't need to be combusted?
Yeah, so we have a couple projects that we're evaluating right now. One is to power our injection pump that we use for pressure maintenance in the field for the water flood. We're going to look at the feasibility of powering that with natural gas. And we also have a number of wells that are on line power currently. And we're going to look at the feasibility of switching those out to natural gas powered motors. And then finally, with respect to the water plant, we'd also like to look at whether or not we can power or supplement the power at the water plant with a natural gas powered generator.
Has any feasibility due diligence been done on those potential projects to date, or how long are you expecting kind of an evaluation of that to take?
So to date, the only feasibility that we've really looked at is with regard to powering the wells or lifting the wells with the natural gas motors. We've evaluated which wells would require kind of what size of motor. And then from there, the next step in that is to see where we can source those motors, Also, look at where that gas would come from, whether it be north or south with the new interconnect line. It makes that a lot more feasible. But we need to finish that off. With regard to the water plant right now, like we mentioned, that water plant is actually, shut down pending getting a purchaser for the water. So, we know roughly what our power usage is there. The question is whether or not we even have enough gas to power that. So I'd say it's more in the, conceptual phase. And then with regard to the injection pump, that kind of concept just grew up here since we was right, I don't know, shortly before we made the application. And so we haven't actually started down the path on that yet. We're kind of prioritizing the wells individually first.
Okay. And so when you talk about not having enough gas, that would be not having enough gas for the water plant in addition to everything else that you're currently doing and considering doing, or that would be period.
Yeah.
You wouldn't have
Yeah,
enough.
correct. We could, if we implemented all of these, I think it's possible that we could actually exceed we may actually have more demand than we have supply, depending on how large of a generator we end up with out there. The other issue is that, and that one's going to take a lot more work because obviously disruptions at the water plant then have this knock-on effect to the rest of the field. So we have to look at the reliability and the uptime of the generator. So it's that one I would say is going to be a little more involved than the others. So that's kind of where we are on those.
Okay. And so one of the things I kind of want to get to the bottom of is 12 months from now, if we're to grant this application, are we going to come back and say we're still looking at potentially doing the water flood pump, we're still potentially looking at the water plant, but now, hey, now we're up a couple percentage points because now we've stopped electrifying our pump jacks and we're actually using natural gas pump jacks for a couple of our other wells?
Sorry, I don't think I caught the question was, do I think that we will have
is that essentially what we're going to hear in 12 months is we need another 12 months because we're still looking at additional things. We haven't found any place to be able to move the gas. So we're still kind of status quo, but now we've maybe added a natural gas generator to one pump jack or two pump jacks.
Right. No, I mean, I don't think that's our intention. Our intention is to continue to, work these, in a very thoughtful way and start to, get down the road for each one of these and, get the evaluations completed, both from a technical and an economic perspective. And no, I mean, it's not our intention to be here saying that, none of these worked or only one of them worked. I obviously can't determine in advance how those are going to turn out, but it is beneficial to us as well if these prove to be feasible. So it's definitely something that we fully intend to continue to work on.
Okay. And then I think my final question is, have you had any conversations with utility co-ops or anybody else like that about the potential of them buying? Are they simply kind of maxed out on what they can take in terms of gas to help with energy sources, or have you had those discussions at all?
So those discussions were had previously. The main issue was the distance to the pipeline. Pipeline is several miles away, and the cost is just massively prohibitive to tie the gas in. Whether they need the gas or not, I don't know that the discussion ever got that far. And I do know that nothing has changed with regard to the proximity of the line. So I would say, in the last 12 months, we haven't had any new discussions with them. But the best that we can discern, and I think we're right about that nothing has really functionally, changed in that space. It's obviously not something we're against doing, but it just didn't seem like the factors that made it, infeasible before had changed since we were here last.
And so as a follow-up to that, as you talk about it being massively prohibitive to kind of endure those costs, was part of the discussion that you would have to build the pipeline out to it, and you simply cannot afford to build the pipeline, or you couldn't get rights of way, or
It's just solely the cost of the pipeline. It would consume all of the profits from the field for many, many years. In fact, it would be, I don't even know how many years it would be. I'd go back to the old study, but it was many, many, many years, to the point that you could almost argue it may not pay out. And it does have to cross, I believe, an irrigation canal, and goes across a lot of farmed property as well. But that in and of itself wasn't the prohibitive issue. The issue was just it is a long way for a field that makes this small of amount of gas. And I'm not sure to what extent this much gas would make an impact for them. I'm not saying they wouldn't be willing to take it, but it's such a small volume. I think there could be potentially issues there as well.
And if I may interject real quick, I apologize. If I don't know if you commissioners have access to our exhibits, we did file those. As you may recall, we were initially scheduled for October 15th, so we had filed our exhibits and initial presentation back then. If it's in part of your portfolios, Exhibit D, or I could screen share, we do have a map to kind of show the distance and the hurdles to connect to those pipelines. 6 to 7 miles from the North Tank Battery to the Rawhide Energy Station, as well as about 12 miles from the South Tank Battery to the Tallgrass natural gas pipeline. So there are pretty substantial hurdles getting there, and I'm happy to, like I said, if I need to share the screen, or if you guys have the exhibits and Exhibit D available to take a look at, that might help to kind of get an idea of what we're up against.
Understood. And yeah, we have access to Exhibit D there. And I guess one question for you, Mr. Chapman. I know you talked about doesn't violate the intent of the act, and you cite to the Martinez case. Do you have any arguments that are applicable to the current statutory mandate and intent of the act as opposed to pre-19181?
Well, I can't say that I have a specific cite to one. I was always kind of going off that one as being pretty substantive, but I do understand that times change and statutes change. But I don't know if the intent of the commission has really changed, other than taking into account, the safety of the public health, the safety and welfare of the environment, and the wildlife resources as determined by the commission and you guys yourselves. And I do still believe that the goal is to promote the production of oil and gas in Colorado. So while I may not have a more recent site on hand, I believe that site still kind of holds up.
Okay, thank you.
Any other questions? Okay, thank you for your presentation and answer to the questions. Commissioners, let's go into deliberations. Any commissioner care to kick us off? Commissioner Messner.
Thanks, Madam Chair. I have a few different thoughts on this one. Mr. Chapman, I will tell you that the mission of the Energy and Carbon Management Commissions has changed, and we no longer foster oil and gas development with the consideration for protection of public health, safety and welfare, and the environment, but rather we regulate oil and gas in a manner that ensures the protection of public health, safety, welfare, the environment, and wildlife resources. That was a significant change that was done in 2019 with the implementation of Senate Bill 19181. And so the mission of the agency has changed. It has changed significantly, and I think it's important to note that. I think that Rule 903, which was developed during the mission change rulemaking, or modified significantly during the mission change rulemaking, Rule 502C as well, lays out pretty specifically like what the expectation is of this agency and what the expectations are of the act and the rules associated with flaring. And I think it's important to note that there is a number of elements that are needed to be addressed as the applicant has the burden of proof in asking for a variance. And certainly there's elements associated with the variance, which is 502C. There's also requirements in Rule 903 as far as things that need to be addressed as part of a gas capture plan. And understanding that that gas capture plan would be submitted to staff, addressing how these things were going to be addressed to this commission in these proceedings, I think is an important piece as well. I think the applicants provided a lot of information. I appreciate that, but as I look at the information, I am not seeing a path forward here. For me, I don't see this being a temporary 12-month extension or variance. I don't see significant process happening or significant improvements towards accomplishing what the requirement is in the rule in the act. And the requirement is that there be no routine flaring and venting in oil and gas operations in the state of Colorado. There are some exceptions associated with that. This operator has certainly utilized those exceptions a number of times now. Those exceptions, began in 2022. That gives this operator, or this operator has, in 2021 it started, and then in 2022 it was an operator was allowed to ask for an extension, and I think this operator has asked for a number of extensions now. I think that in my mind, the rules in the act clearly indicate that the flaring of natural gas is impactful to public health, safety, welfare, the environment, and wildlife resources. And I think it's explicit in the rules that it states that there are opportunities that are provided to operators to beneficially utilize that natural gas in a number of different mechanisms. We've seen a number of different applications before us that have utilized really unique and forward-thinking ways to beneficially utilize that natural gas. They've been proactive in chasing different opportunities so that they could be in compliance with the rules rather than asking for continued variances over and over again. I'm not seeing that necessarily happen in this particular instance. I'm seeing some efforts being made, but I think a lot of those efforts had previously been made or were historically already part of operations. The reality in my mind is that there's been 4+ years that the operator has had the opportunity to look at opportunities for beneficially utilizing the full amount of the natural gas associated with operations in this area. The development of the necessary infrastructure in order to address the gas and the oil is a cost of doing business in the state of Colorado, in my mind. I always find it interesting that there's always ways to figure out how to develop pipeline infrastructure for the most profitable of the products, whatever that most profitable product may be from a particular situation. But there's never seems to be enough money in order to develop the necessary infrastructure for the associated byproducts, whether that be produced water or whether that be natural gas in this particular instance. And so in my mind, I think there's been enough time to really explore opportunities to developing the necessary infrastructure in order to be able to develop oil and gas in this particular region. And I've not seen any significant progress on that. There's also an opportunity to develop no net adverse impacts by looking at ways to mitigate the flaring in instances where flaring needs to occur. I didn't see any significant efforts made for developing mitigations for that, which would be another potential pathway forward for this operator. It was a little disturbing to hear that one of the potential solutions was going to be to remove line power from operations, which has a significant, decrease in emissions associated with it, and replace it by the utilization of natural gas generators. That would be a net increase in impacts, not a net decrease in impacts. And so that seems to be problematic for this application as well. And so, begrudgingly understanding that this is a difficult situation for this operator to be in, I'm not sure that the applicant has met their burden of proof to be granted a variance in this particular instance. And so I'm not inclined to support that from this commissioner's standpoint, but certainly, as always, open to other commissioners' thoughts, which may influence my final decision.
Thank you, Commissioner Messner. Commissioner Cross?
Thank you, Madam Chair. I'll try to be brief. I'm in complete agreement. I think that the fact that nothing really new has been done in the last year, and at most all we're seeing for a further extension is maybe trying to see if we can even be a little bit more efficient, it is not an ultimate solution here. I'm glad that they've moved up to the 98% efficient ECDs, but ultimately an ECD is supposed to be there in cases of emergency, in cases of maintenance, things like that, not as a solution to flaring needs and saying, oh, well, because it's going to be 98% efficient combustion, it's not really a problem. As Commissioner Messner indicated, I think trying to switch off of line power, while maybe beneficial to other electric users in the area, at the same time, the increase in emissions of that is not something that's going to have a net benefit for public health, welfare, safety, the environment, and wildlife resources. And we've seen some maybe far-fetched ideas from other people proposed at times, but we've also seen things from greenhouses being powered to trying to have it liquefied so it can be transported to other places easier to avoid pipelines and things like that. And I don't know if some of those would be possible here, but the fact that we've had at least those ideas portrayed to us in other hearings and other variance requests for this, and we're kind of getting, let's just keep with the status quo and see if we can be a little bit more efficient, is not really something to me that says this variance should be supported. Recently I was asked the question, is it impossible for small operators to operate in Colorado? And I said no, and I still think it is entirely possible for small operators to operate in Colorado. But as Commissioner Messner indicated, I think this is one of the costs of operating in Colorado, is that you have to deal with our more stringent regulations, and not flaring is one of those. And so I think trying to say, oh, well, we've moved from 60% to 62% and 70% to 80% or whatever the numbers were, I don't have it in front of me, in terms of how well we've utilized it, even though we haven't really done anything new to utilize it, just how we've moved that gas throughout between the north and the south tanks there, is not really an explanation of efforts necessary based on what we have said to this applicant in the past, as well as what we've said to other applicants seeking a variance in the past. So I'm in agreement with Commissioner Messner. I'm not prepared to grant a variance for this.
Thank you, Commissioner Cross. I would just note quickly that I also am in agreement. Commissioner Ackerman?
I'm sorry, Madam Chair, I didn't mean to cut you off. I'm happy to wait till you're done and then.
Nope, not at all. Please go ahead.
Okay, thanks so much. I want to recognize that it's a tough requirement. It is a tough requirement, and it was intentionally so. The intent of the commission at the time of the passage of these rules was specifically to protect public health, safety, welfare, the environment, wildlife resources, and to eliminate energy waste. And so I just wanted to kind of, all my points have been touched on by my fellow commissioners, but I did want to talk about what we said in the basis and purpose, a little bit associated with this concept on page 89. It says, consistent with its statutory obligation to prevent waste, the Commission intends to phase out routine venting and flaring from producing wells within 1 year of the effective date of the 800, 900, 1200 mission change rulemaking. The Commission recognizes that some time is necessary for infrastructure issues to be resolved. So certainly the intent of the Commission was not an ongoing apply for a variance while making incremental progress over a period of multiple numbers of years. It continues, the Commission staff may approve a request to continue venting or flaring for a maximum period of 12 months, but in no case will the Commission staff approve a request to continue venting and flaring beyond January 15, 2022. Thus, if an operator's prior Form 4 approval to vent or flare under Rule 912 expires in December 2021, and the operator submits a request to continue venting and flaring in December 2021, the Commission staff could only approve the request for a duration of 1 month rather than approving it for a 12-month period. And so the intent was certainly for the interim period, for there to be significant action taken during that interim period when staff could grant requests. It kind of finishes by saying, though disfavored, operators may request an extension to the one-time request to flare or vent natural gas by seeking variance from the Commission pursuant to Rule 502. I think this solidifies that the intent is not long-term, and it's tough to say where's the endpoint, but I think we have reached well beyond that endpoint in this case, and so I'm in agreement with the sentiment expressed by my fellow commissioners.
Great. Thank you all for your thoughts. As I said briefly, I also am in agreement. So it looks like we have consensus here. Would any commissioner care to make a motion?
Madam Chair, I'm happy to make a motion. I would move denial of the variance request as I find that the applicant has not made a good faith effort to comply with the specific requirements contained in the Commission rules. That the requested variance would violate the basic intent of the Act, and that the granting of the variance would result in a net adverse impact to public health, safety, welfare, the environment, and wildlife resources.
Second.
Great. We have a motion and a second. All in favor? Aye.
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 Any opposed? Motion carries 4-0. Thank you very much. Okay, so commissioners, that was the last item on our agenda for today. So we are concluded with our business. I would make a motion to adjourn.
Second.
All of those in favor? Aye.
Aye.
Any opposed? Motion carries. Thanks all, and please stay safe.